order of Mr. Justice Supperstone made on the 29th of March 2019, by which he refused permission to apply for judicial review of the making of Regulation 9 of the Human Medicines Amendment Regulations 2019, the 2019 regulations. Regulation 9 amends the Human Medicines Regulations 2012, the 2012 regulations, by the insertion of a new Regulation 226A concerning the sale or supply of prescription-only medicines by retail pharmacists in accordance with a Serious Shortage Protocol, or SSP, which ministers may issue in circumstances where the UK or any part of it is, in their opinion, experiencing or may experience a serious shortage of such medicines. Although not formally linked to Brexit, the amendment is said to have been made in preparation for the possibility of a no-deal Brexit. The essence of the SSP arrangements is that where a prescription-only medicine prescribed by a doctor is subject to a serious shortage, a pharmacist can dispense a different strength, quantity, or pharmaceutical form of the medicine, or a different prescription-only medicine, as indicated in the protocol, and subject to the professional skill and judgment of the pharmacist as to the reasonableness and appropriateness of what is dispensed. The concerns underlying the present challenge relate to the risks said to arise from replacing or interfering with the clinical judgment of the prescribing doctor and bypassing the relationship between doctor and patient through the supply of medicine by the pharmacist in accordance with a centralized protocol, rather than by the pharmacist contacting the doctor for the doctor to prescribe an alternative. The issues before the court relate, however, only to the lawfulness of the regulation, not to the substantive merits of the measure. Moreover, the regulation establishes only the principle of supply in accordance with SSPs. The development of the operational detail has been left to the next stage of the process. It is contemplated, for example, that SSPs will be developed with and signed off by clinicians, and that they may not be suitable for some high-risk patients or some medicines. 4 grounds of legal challenge were advanced before Mr. Justice Supperstone. Only one of them is still pursued. The single ground of appeal is that Regulation 9 is ultra vires Directive 2001-83-EC of the 6th of November 2001 on the Community Code relating to medicinal products for human use, the directive, as well as the Medicines Act 1968. Under the umbrella of that ground, it is contended first that Regulation 9 is prohibited by the directive, secondly that the regulation falls outside the powers of Section 2, subsection 2 of the European Communities Act 1972, pursuant to which it was made, and thirdly that the regulation is prohibited by Section 64 of the Medicines Act 1968. The application for permission to appeal was directed into open court by my Lord Justice Hickinbottom. We've heard today from Mr. Stephen Naffler, Queen's Counsel for the applicant. The Secretary of State has chosen to be represented at the hearing, though not directed to do so. In the event, it has not been necessary to hear from Sir James Eadie, Queen's Counsel, on the Secretary of State's behalf. The legislative framework. The 2012 regulations consolidate most of the previous UK legislation regulating the authorization, sale and supply of medicinal products for human use. They give effect to and elaborate upon the directive and a number of other EU directives. This case concerns medicinal products classified as prescription-only medicines. The classification of medicinal products is governed by Title 6 of the directive. Within that title, Article 70 provides that when a marketing authorization is granted for a medicinal product, the competent authorities shall specify the classification of the product into 1, a medicinal product subject to medical prescription, or 2, a medicinal product not subject to medical prescription. A medicinal prescription, which I take for today's purposes to be the same as a medical prescription, is defined by Article 1, paragraph 19, as, quote, any medical prescription issued by a professional person qualified to do so, unquote. The process of classification is governed by the criteria laid down by Article 71. For example, medicinal products are to be subject to medical prescription where they are likely to present a danger if utilised without medical supervision. I will refer to further provisions of Article 71 when considering the first issue. The classification requirement is transposed into UK national law by Regulation 5 of the 2012 regulations. Regulation 5, paragraph 3, provides that references in the regulations to a prescription-only medicine are to a medicinal product that is covered by an authorisation, of which it is a term that the product is to be available only on prescription, or to a medicinal product that is classified as prescription only by various other routes. Part 12 of the 2012 regulations is headed Dealings with Medicinal Products. Chapter 2 of Part 12 concerns the sale and supply of medicines. It provides by Regulation 214, paragraph 1, that, quote, a person may not sell or supply a prescription-only medicine except in accordance with a prescription given by an appropriate practitioner, end quotation. By paragraph 7, however, quote, this regulation is subject to Chapter 3, exemptions, unquote. Prior to the amendment made by the 2019 regulations, Chapter 3 of the 2012 regulations already contained numerous exemptions, including various exemptions for emergency supply by pharmacists and exemptions for supply in accordance with a patient group direction. The challenged Regulation 9 of the 2019 regulations inserts a new regulation, 226A, into the list of exemptions. It reads as follows, quote, 1. Regulation 2141 does not apply to the sale or supply of a prescription-only medicine by a person lawfully conducting a retail pharmacy business if conditions A, B, and C are met. 2. Condition A is that the prescription-only medicine is sold or supplied for the purpose of being administered to a person in accordance with a serious shortage protocol, SSP. 3. Condition B is that the requirements of the SSP are satisfied in respect of to whom and subject to what conditions the prescription-only medicine may be sold or supplied for the purpose of being administered. 4. Condition C is that the sale or supply of the prescription-only medicine is by or under the supervision of a pharmacist who is of the opinion, in the exercise of his or her professional skill and judgment, that A, in a case to which paragraph 5b(1) applies, the sale or supply of a different strength, quantity, or pharmaceutical form of the prescription-only medicine to the strength, quantity, or pharmaceutical form of the prescription-only medicine ordered by the prescriber is reasonable and appropriate, or B, in a case to which paragraph 5b(2) applies, the sale or supply of 1, a prescription-only medicine other than the prescription-only medicine ordered by the prescriber is reasonable, and 2, the substituted prescription-only medicine in accordance with the directions for the use that he or she specifies is appropriate. 5. For the purposes of this regulation, an SSP is a written protocol that A is issued by the ministers, in circumstances where the United Kingdom or any part of the United Kingdom is, in the opinion of the ministers, experiencing or may experience a serious shortage of a prescription-only medicine or prescription-only medicines of a specified description. B provides for the sale or supply by or under the supervision of a pharmacist and subject to such conditions as may be specified in the SSP, 1, of a different strength, quantity, or pharmaceutical form of the prescription-only medicine to the strength, quantity, or pharmaceutical form ordered by the prescriber, or 2, of a prescription-only medicine other than the prescription-only medicine ordered by the prescriber. C provides in a case to which subparagraph B2 applies that the other prescription-only medicine is to be 1, a generic version of the prescription-only medicine being substituted, or that both products are generic versions of another prescription-only medicine. 2, in the case of a biological medicinal product, a similar medicinal product to the prescription-only medicine being substituted, or that both products are similar medicinal products to another biological medicinal product. Or 3, a prescription-only medicine that has a similar therapeutic effect to the prescription-only medicine being substituted. And D specifies the period for which, and the parts of the United Kingdom, which may be all of the United Kingdom, in which the protocol is to have effect. I will take the main issues in the order in which they're set out in Mr. Nathal's written skeleton argument, although they have been developed in a slightly different way in his oral submissions. Compatibility with the directive. The The first main issue is whether Regulation 9 is in breach of the directive. The judicial review grounds of claim do not themselves allege such a breach. They contend only that Regulation 9 does not implement any obligations or rights found in an EU instrument and is not otherwise within the boundaries of Section 2.2 of the European Communities Act 1972, a separate point to which I will turn next. A breach of the directive was, however, raised in the applicant's reply to the Secretary of State's summary grounds of resistance to the claim. It appears to have been touched on in argument before Mr. Justice Supperstone, see paragraph 14 of his judgment, and in any event, no objection has been taken to it being advanced before us in the form set out in the grounds of appeal and accompanying skeleton argument. Mr. Knafler's submission may be summarised as follows. Articles 70 and 71 of the directive, taken with the definition of medicinal prescription in Article 119, require the UK to classify medicinal products as being subject to prescription and thereby only issuable by a professional person qualified to prescribe them when any of the criteria in Article 71 are satisfied. Regulation 9 is in breach of those provisions because it allows the Secretary of State to issue an SSP and thereby to authorise pharmacists to sell patients prescription-only medicinal products otherwise than in accordance with a prescription issued by a professional person qualified to do so, such as a doctor. Neither government ministers nor pharmacists, unless they are a pharmacist independent prescriber, are professional persons qualified to prescribe medicinal products. The sale of prescription-only medicinal products under an SSP is a sale to patients of such products otherwise than in accordance with a prescription issued by a professional person qualified to do so. That, in Mr. Knafler's submission, is in breach of the directive. The fundamental difficulty about that line of argument is that Articles 70 and 71 of the directive lay down requirements as to the classification of medicinal products into those subject to medical prescription and those not so subject, not as to the conditions on which medicinal products classified as subject to medical prescription may be sold or supplied. It may be inherent in the directive that medicinal products subject to medical prescription are, as a general rule, to be supplied to the public only in pursuance of a prescription. But Articles 70 and 71 do not impose, either expressly or impliedly, an obligation on member states to prohibit all supplies of such products otherwise than in pursuance of a prescription. To read these classification provisions as imposing such an obligation and as depriving member states of any discretion or flexibility in the matter would, in my view, be to read far too much into them. Indeed, the articles themselves point to the existence of a considerable degree of discretion in this area. Whilst Article 71, paragraph 1, sets out the criteria governing, for the purpose of Article 70, paragraph 1, the classification of medicinal products as subject to medical prescription, and Article 71, paragraphs 2 and 3 provide for subcategories of medicinal products subject to special medical prescription and those subject to restricted prescription. Article 71, paragraph 4 states as follows, I quote, "A competent authority may waive application," paragraphs 1, 2 and 3, having regard to A, the maximum single dose, the maximum daily dose, the strength, the pharmaceutical form, certain types of packaging, and or B, other circumstances of use, which is it has specified, quotation. If such a discretion exists in the competent authority of the member state in relation to the classification of a medicinal product as subject to prescription in the first place, it would, in my view, be very surprising if no discretion existed for the member state in relation to the conditions of supply of such a product. In reaching my conclusion on this issue, I've also taken into account the wider context as it appears from the directive. Recital 29 states that the conditions governing the supply of medicinal products to the public should be harmonised. Recitals 31 and 32 show that the classification provisions are themselves an aspect of harmonisation. Recital 35 states that it is necessary to exercise control over the entire chain of distribution of medicinal products from their manufacture or import into the community through to supply to the public, though the stated purpose of that recital is to guarantee that such products are stored, transported and handled in suitable conditions. Against the background of those and other recitals and the substantive provisions of the directive, it is accepted in the Secretary of State's summary grounds of resistance that the UK must have an effective and proportionate scheme for enforcing the supply of prescription-only medicines to the public. But it is said that this is achieved through Part 12 of the 2012 regulations, with its basic prohibition on the sale or supply of prescription-only medicine except in accordance with a prescription, and its list of exemptions from that basic provision, including now the exemptions inserted by Regulation 9. The directive cannot, in my view, be read as precluding that balanced approach. And although Mr. Nafta says that the exemption inserted by Regulation 9 is the only exemption to allow for a pre-existing specific clinical judgment to be interfered with by a pharmacist, I see no difference of principle so far as concerns compatibility with Articles 70 and 71 of the directive between the Regulation 9 exemption and at least some of the other exemptions in the 2012 regulations that allow sale or supply of prescription-only medicines otherwise than in accordance with a prescription, provided that carefully defined conditions are met. For example, Regulation 247, which exempts supply of a medicinal product in the event or anticipation of a pandemic when the supply is in accordance with a protocol approved by the ministers or an NHS body. I accept that the lawfulness of those other exemptions is not an issue in these proceedings. But I attach weight to the fact that the impugned regulation forms part of and is in line with wider regulatory arrangements that have not been challenged, and I find it difficult to accept that the directive can have the effect of prohibiting arrangements of this kind altogether. Having regard to the various points to which I have referred, I would reject as unarguable the applicant's case in relation to the first main issue. The European Communities Act 1972. The second main issue is whether Regulation 9 is within the boundaries of Section 2, subsection 2 of the European Communities Act 1972, which provides, so far as material, that a designated minister may make provision, quote, A, for the purpose of implementing any EU obligation of the United Kingdom, or enabling any such obligation to be implemented, or for enabling any rights enjoyed or to be enjoyed by the United Kingdom under or by virtue of the treaties to be exercised, or B, for the purpose of dealing with matters arising out of or related to any such obligation or rights. End quotation. The Secretary of State relies on Section 2, subsection 2b as the enabling power. Mr. Justice Supperstone found that Regulation 9 plainly fell within it on the basis that the management of shortages of prescription-only medicines is a matter arising out of and related to EU obligations under the directive to classify certain drugs as prescription only and to control their supply. See paragraph 16 of his judgment. Mr. Nafta admits that the judge was wrong to reach that conclusion. He cites the judgment of Lord Mance in United States of America against Nolan, 2015, UK SC 63, 2016 appeal cases 463, at paragraphs 59 to 62. In particular, at paragraph 61, Lord Mance described the relationship between subsections 2a and 2b of section 2 and the effect of subsection 2b in these terms. Quote, what can in my view be said from the wording and positioning of these two paragraphs is that paragraph A is the main vehicle for implementation of EU obligations and rights which are not directly enforceable. Paragraph B goes further in authorising provision for different purposes, but those purposes are limited by reference to the United Kingdom's EU obligations or rights, ... The words arising out of limit the power to provisions dealing with matters consequential upon an EU obligation or right, ... The further phrase, related to any such obligation or rights, must, unless redundant, go somewhat further. But the relationship required must exist objectively, and the positioning of the phrase in its conjunction with the earlier wording of section 2, subsection 1, suggests to me that by speaking of a relationship, the legislature envisaged a close link to the relevant obligation or right. A relationship cannot, in any view, arise from or be created by a simple ministerial decision that it would be good policy or convenient to have domestically a scheme paralleling or extending EU obligations in a field outside any covered by the EU obligations. That would be to treat paragraph B as authorising a purpose to implement policy decisions not involving the implementation of, not arising out of, and unrelated to any EU obligation. End quotation. In the light of those observations, Mr. Nafler submits that Section 22b only authorises regulations for the purpose of dealing with matters arising out of or related to an EU obligation when those regulations are in furtherance of or consistent with and closely related to the relevant EU obligation. He refers also to the expression, quote, tidying things up, unquote, which was used by Lord Justice May as a partial statement of the effect of Section 22b in an earlier case, as quoted by Lord Mans at paragraph 57 of his judgment in Nolan. Mr. Nafler submits that Regulation 9 is none of these things. First, because it contradicts or is inconsistent with Article 71 of the Directive, and secondly, because although it creates a scheme that in the view of the Secretary of State would be good policy or convenient to have, it has a different aim and covers matters significantly beyond the scope of the Directive. The regulation therefore falls outside the powers conferred by the subsection. Mr. Nafler emphasises the constitutional point that any legislation going beyond the limits of the subsection is a matter for Parliament to decide. I have held already that Regulation 9 does not contradict or involve any inconsistency with the Directive. Equally, in my view, it does not have a different aim from the Directive or cover matters significantly beyond the scope of the Directive. The matters covered by Regulation 9, namely the conditions governing the supply of prescription-only medicines in times of serious shortage, are in my view plainly within the field covered by the Directive and are indeed closely related to the obligations contained in the Directive. I am satisfied that the close link required by Section 22b exists in this case and that the judge was correct to dismiss as unarguable the contention that the regulation is ultra vires, Section 22 of the 1972 Act. The Medicines Act 1968. The third main issue is whether Regulation 9 is prohibited by Section 64 of the Medicines Act 1968. Section 64, subsection 1 reads, quote, no person shall, to the prejudice of the purchaser, sell any medicinal product which is not of the nature or quality demanded by the purchaser, unquote. This must be read, however, together with subsection 5 of the same section, which reads, quote, where a medicinal product is sold or supplied in pursuance of a prescription given by an appropriate practitioner, the preceding provisions of this section shall have effect as if A, in those provisions any reference to sale included a reference to supply, and, except as provided by the following paragraph, any reference to the purchaser included a reference to the person, if any, for whom the product was prescribed by the practitioner, and B, in subsection 1 of this section, for the words demanded by the purchaser, there was substituted the words specified in the prescription. End quotation. Mr. Justice Supperstone held that Regulation 9 does not involve any breach of Section 64. Under the exemption inserted by Regulation 9, one of the conditions to be satisfied is that the prescription-only medicine is sold or supplied for the purpose of being administered to a person in accordance with a serious shortage protocol, Condition A, in paragraph 2 of the inserted Regulation 226A. The judge held in paragraph 18 of his judgment that where a prescription-only medicine is sold or supplied for the purpose of being administered to a person in accordance with a serious shortage protocol, it is not sold or supplied in pursuance of a prescription, and does not therefore fall within the prohibition in Section 64. He accepted at paragraph 19 the description of SSPs given by counsel for the Secretary of State as a parallel system to prescriptions, which will only operate if, pursuant to Regulation 226A5A, ministers decide that the UK or any part of the UK is experiencing or may experience a serious shortage of prescription-only medicines of a specified description. He also observed in paragraph 20 that the effect of Regulation 226A is to maintain the classification of the medicine to be supplied as prescription only, but to change, in the circumstances set out in Regulation 226A2, the instrument by which the medicine is supplied from prescription to serious shortage protocol. Mr. Nafler submits that the judge was wrong so to hold. He says that despite the existence of an SSP, the sale is still in pursuance of a prescription, and that Section 64 is therefore engaged. There would not be a sale or an SSP were there not a prescription. In other words, a prescription is a conditioned precedent to the dispensing of medicine under the SSP. The judge placed a weight on the expression in pursuance of a prescription that it cannot have been intended to bear. Where there is a prescription, but the pharmacist, for whatever reason, sells the patient different medicine, Parliament must have intended that to be a sale in pursuance of a prescription. Parliament cannot have had in contemplation or have intended to authorise an instrument interposing itself between the doctor's prescription and the pharmacist's sale, rendering the prescription a dead letter, and rendering irrelevant the professional opinion of the patient's doctor as to what alternative medicine should be prescribed. The judge's reading in Mr. Naffler's submission drives a coach and horses through the protection that Section 64 was intended to provide. And here too he raises the constitutional point that if the protection conferred by Section 64 is to be overridden, that must be done by means of legislation made by Parliament. For my part, I do not find Mr. Naffler's submissions on this issue at all persuasive. It seems to me that the sale or supply of a prescription-only medicine on the conditions laid down in the inserted Regulation 226A, including that it is sold for the purpose of being administered to a person in accordance with an SSP, falls clearly outside the mischief at which Section 4 of the 1968 Act is directed, even though Parliament will not have had the specific situation in contemplation at the time of enactment of that Act. It is, of course, true that in an SSP case, the process starts with a prescription of a medicine which, ex hypothesi, is or may be in serious shortage, so that the prescription is in a sense a conditioned precedent to the rest of the process. But the judge was, in my view, plainly correct to draw the distinction he did, and to hold that a sale or supply that meets the conditions of Regulation 226A and is therefore made in accordance with an SSP is not a sale or supply in pursuance of a prescription within the meaning of Section 64 of the 1968 Act. Again, I consider the contrary to be unarguable. Conclusion. I have borne in mind throughout that we are concerned ultimately in this case with the threshold of arguability for a judicial review challenge. However, for the reasons I have given in relation to each of the main submissions advanced under the umbrella of the single ground of appeal, I take the view that an appeal against the refusal of permission to apply for judicial review would have no real prospect of success, and that permission to appeal should for that reason be refused.
I agree.
My Lords, if I can trouble you very, very shortly in relation to costs.
Yes.
The rule that applies...
Sorry, has any cost order been made by Mr. Justice Supperstone?
No, we're still waiting for a reaction on that. There have been written submissions in relation to it, and my Lord will have seen, I think, that Mr. Justice Swift ordered a certain amount of costs.
Oh, right, okay.
On the Mount Cook basis, unsurprisingly, because he did it on the papers. Then there was a hearing before Mr. Justice Supperstone where he effectively reserved his judgment, and I made an application we've made an application for costs. There are written submissions on that issue that are before the learned judge and awaiting disposition.
Yes.
So that's the position we have at the moment.
Yes.
My Lords, the rule that applies so far as you are concerned
Yes.
is contained in the White Book at page 1857. I'm aware from a statement in my Lord Sir Stephen Richards' judgment that he is already aware of this rule, because at 1857 at the bottom it's paragraph 20 within practice direction 52C, and the basic position, if I can summarise it, as you see from sub 1 and sub 2 of para 20, is that normally, where there hasn't been a direction, an award of costs for attendance at the hearing will not be made, and that position is reversed if the court does make a direction for attendance. There has been no such direction in this case, although the court did list it for the convenience of counsel, for which we're very grateful.
And I think this is right. Somebody will correct me if I'm wrong. I think we were asked quite recently whether we had made a direction. Whether we required you to attend.
Well, we didn't ask.
No, I may be wrong.
Yeah. I don't think there's been an outright refusal to make a direction, if that's the point my lord is putting to me.
No, I thought I had, but
Otherwise, someone might have told me. But I think that isn't the position. My
Yeah.
lord has other information, and I'm happy to.
No.
Anyway,
sure
the position can be assumed that the position is not normal is the test I have to confront. And my submission, for three very short reasons, is that this is not normal. The first is the importance of the issues raised by this appeal, including in particular the serious consequences that might flow or might have flowed if the court's judgment had been different. The second is that, as my lord and my lords have already commented, on appeal, far greater focus was placed on the argument that there was a breach of the directive, which was a point which had been raised briefly below in the reply, as my lord's judgment pointed out, had been touched on very briefly at the hearing before Mr. Justice Supperstone, but no more than that, but has provided the principal focus of the submissions in writing and now orally on this application to this court. So effectively, new focus, new principal focus of the argument is the second reason why we say we're within the not normal provision. And the third point, briefly, is consequential, effectively, on the first two. I fully appreciate that my lords, with their long experience of my limited ability to assist the court orally, have decided that in the end you don't require assistance orally, but that potential was always there. The provisions are not uncomplicated. Whether I could have answered all the questions that my lord might have put to me about those provisions is a different matter, but we thought it right at least to attend for the purpose of offering assistance on a scheme which is not uncomplicated. So for those three reasons, we do respectfully submit that the costs of the attendance is appropriate to be awarded in principle. In terms of the practicalities, given the position as I outlined it at the beginning in relation to Mrs. Justice Supperstone being seized of it, one possibility, if you are persuaded by the principal position, is for the court to award the costs of attendance in principle and for submissions as to amount to be remitted back to Mr. Justice Supperstone to fall within the pot that he's already examining.
Just two points. Firstly, and again, simply by way of information, you didn't, the respondent didn't put in any written submissions to this hearing. We've obviously we've had the benefit of your submissions before Mr. Justice Supperstone, which he effectively accepted.
We didn't, and the reason we didn't was to try, as it were, to keep costs to the minimum.
No, I understand that, and you'd made your position clear. Secondly, in relation to the first point you made, the serious consequences of the judgment, the consequences of the judgment, if it had gone against the respondent, would have been that there would have been a substantive hearing, probably this term.
And probably urgently.
I mean, urgently, because of the...
Because part of it was Brexit shortages in the event of no deal.
Yes, so we would have had to deal with it before October. So the serious consequences of this judgment would have been limited. I understand that the potential consequences of any ultimate decision. But
my lord, of course, I don't say that the grant of permission would itself have created crisis, but in judging the seriousness of the issues for the purpose of justifying attendance, one looks a bit beyond that, and there's obviously a massive advantage in the matter being disposed of quickly and swiftly as you've done.
I understand.
From the government's perspective.
Yes, I understand.
My lord,
There is, under the current rules, provision allowing a respondent to an application for permission to be able to put in written submissions at the application stage, is there? That is
yes, and I think we put in a short notice of objection. No, perhaps we didn't.
I don't
No,
think
we
you
didn't even do that. No.
Your point about the
No.
directive issue being, well, if not entirely new, at least a different focus, might have been dealt with by a short written submission, providing any contributions you had, rather than by attendance.
My lord, that's possible. It could have been, but again, one never quite knows where the focus is ultimately going to be placed when someone stands up on their feet. I respectfully submit that isn't a point that can be held against this application. Given that we didn't do it, we are here. We could have done it then and not been here, perhaps. One doesn't know, but we've tried to address that in a responsible and proportionate manner, which required a judgment about how best we could at least potentially assist.
I understand. In fact, Mr. Nathless focused in his oral submissions was the same as his written submissions.
That's true as it turns out.
As it turned out.
He didn't depart from any of his written submissions.
My lord, no, after a bit of gentle pushing. But yes, you're right. But as I say, those are the bases on which we respectfully submit that this isn't the normal situation. I know, I'm very well aware, and I don't take you back to it, I'm very well aware that my Lord Justice Hickinbottom has recently considered very similar looking provisions in the context of a permission application in the Wilson case, if you remember that, about quashing the referendum, and what the exceptions to the Mount Cook order might look like, which contained, again, a not normal or exceptional a set of principles in there. And
but I mean, well, firstly, these things are clearly quintessentially fact and circumstance specific. And my recollection in that case is that the I forget who it was, but the applicant was not as rigorous as Mr. Nutter has been in keeping to the issues that have been raised earlier.
that is true, but I think my Lord's judgment on costs focused in particular on issues such as whether or not, in effect, all of the arguments of substance had been raised and the court had dealt with them, and the claimant had therefore had that benefit and all of that. I'm not going to reprise that, but I accept it's a not normal test that I have to meet. I've given you the three reasons, and there they are.
Yes, thank you. Mr. Nutter, you're going to say that this is normal. It's not so far out of the bounds of normality that we should give anything other than the conventional order.
Exactly, and I think the kind of submissions that I might have developed out of that have already been put to my learned friend from the bench, and I don't repeat them. Just by way of information in relation to the High Court proceedings, as I recollect, the principle that costs will have to be paid is not in dispute.
Of the oral hearing?
Of the preparation.
Oh right, yeah.
That's not in dispute. It's a question of quantification. It's a question of how much the cost of the oral hearing is being debated about.
But the liability of the oral hearing costs, as I understand it, is in dispute.
Yes.
Yes.
So that's the position there. Here, as I understand it, there hasn't been written submissions from the respondent. There isn't a schedule of costs. Completely understand that a public authority may wish to attend a hearing of this kind. It's perfectly reasonable to want to do that from their perspective. That doesn't mean they pay for it, of course. And I just raise this very lightly, this is all our submissions have been found to be unarguable. But what can't really be doubted is that they raised important public interest issues that concern a number of people. And it is an aspect of that normal order, particularly in a public case, that there is some degree of protection for the appellant. That principle may weigh particularly strongly in a public interest case such as this. So those are my submissions.
Sir James, we do not think that there are sufficient grounds to give you an order on the basis that this is so far outside the bounds of normality that you should we should make anything other than the conventional order.
Tell my clients I've tried.
So far as we're concerned, is no order for costs.
Great.
Good. Thank you both very much.